John, thank you so much for joining us here today. I know today is day one. We're really talking about jury selection, and I wanted to get really right on into the big question. The media is not allowed to be there during jury selection when it comes to this murder trial. Is this familiar? This is one of the first times that we're seeing this. How common is this to happen that we're not able to be here?
It is extremely uncommon. I'm actually kind of surprised at that decision. I have actually tried a significant number of cases, violent crimes over the years that received significant media attention. And it's just kind of understood and accepted that, the camera and the media is going to have, access to the courtroom and to the process. And it's kind of very surprising that the judge did not allow the media in the courtroom during this election. The only thing I can think about, because I'm not aware of the basis of the reason, is there's some concern that there's always a risk that a camera might catch a juror at some point in the process, or someone on the panel, and there must be some kind of concern that with the protests and the outrage of the community, it may cause a risk to the safety of some of the jurors if there's a possibility their identity may be exposed. But again, that is just complete speculation. I've never, ever, in any of the high-profile trials that I've had over the years, over 20, 30 years, I've never seen a judge make this decision.
So what is happening today now behind the closed cameras? So what is going on right now with the judge? Who is in there and what is going on?
So what's going to happen at this point is jury qualification. All the jurors from the jury panel, everyone that received a jury notification and showed up for jury duty, they're all assembled together in one big room, and the judge asks basic questions to make sure that they're all qualified to serve, that they're over 18, they understand the English language, they don't have a felony conviction, they're a United States citizen, and sometimes every now and then somebody slips through the cracks, and they're also individuals that have the option to serve or not serve, and I think like the age cutoff for it might be like 67. It's kind of optional. If you want to, be excused, you can be excused. And there's that general qualification to make sure the people that are present are in fact qualified. Mm-hmm. The attorneys, the people present are the attorneys, the attorney for the defendant, the prosecutors, of course, the defendants there in that process. And everyone receives the jury list or has access to it because that's an important process of deciding how you're going to use your strikes and select your jury. And when I say strikes, each side has a certain number of strikes. Strikes meaning that during the selection process, if they don't want someone on the jury, they can just have an excuse, okay? The limitations are it can't be for race, it can't be based on gender, but if there are factors or circumstances about a particular individual that, one side or one attorney may say, something, hey, because this lady has a 14-year-old son, I don't want her on my panel because she's going to identify too much with the prosecutor. And that's a good example. So everyone has that list. They have, their occupations, whether or not they're married, and all those things are important because you're trying to put together a juror profile. You kind of, you want to kind of always, it's malpractice not to put some thought into what type of juror profile you want on your case. And there are two lists. There's a short list that has a kind of summary, and there's actually a longer list you can request that has more details where they kind of fill out things, in hand, by hand. So you'll find out where somebody works, where their spouse works. So, so if I'm defending child, I want somebody that's a handgun owner, of course. If I'm defending child, I want someone that owns a business. I want someone that's been robbed. Because you want to have jurors that are going to, the funny thing is, the party line for my profession is you want a fair and impartial juror. No, you don't. I do not want a jury that's fair and impartial. I want a juror that's biased to my side of the case as many ways as possible. That's what I'm looking for. So that's the important part about the jury selection process. I'm going to want somebody, like I said, that's been robbed, maybe a victim of a crime, been robbed at gunpoint would be great. So those are some of the things that are just examples of what you're going to be looking for. Now, also during that process, once the panel is qualified, the attorneys typically have what are considered or what are called voir dire questions. And voir dire is when the jury panel is asked questions that give the court and the attorneys some perspective on their beliefs and their biases. For example, in a case like this, you're going to ask the jury panel, have you ever been the victim of a violent crime? Everybody wants to know that. Typically, prosecutors want crime victims on their panel because crime victims are going to identify with the victim. And because of what's happened to them, they're going to want to try to bring somebody justice, either the justice they have or the justice they didn't get. In this case, I think the crime victim can swing both ways based on the facts, because you have a young man that was shot to death, and you have a defendant that's claiming he was a potential victim of violent crime. Other good examples, or standard questions are, if you or anybody in your family has any relationships with anybody in law enforcement or with a prosecution agency. Again, you're looking for bias. You don't want somebody, if you're a defense attorney, you don't want somebody in your panel whose husband is a law enforcement investigator and their brother's a prosecutor and things like that. So you want to keep people like that off your jury. So that's what's kind of going on. Each side has their own list of questions they submit to the judge, and the judge will look at that list and say, okay, I'll ask question number 5. I'm not going to ask question number 7. And from there, they're asked that panel, they all give a response, and the lawyers write down the responses, So that's what's happening at this stage, so they can get a good profile of who exactly is on that panel. And they're also going to look at the people that, they're going to look at the people they want to put on their jury and the people they want to make sure don't get on their jury. You don't want, retired law enforcement on your jury if you're a criminal defendant. And that gives you some insight as to how you're going to use your strikes, because you can use so many strikes just to keep people off. So you're going to be strategic in that. You go, okay, well, hey, I got 4 or 5 retired law enforcement, a lady whose son got killed, in a botched robbery, a woman who feels like, or someone who feels like their child was shot and the person responsible got away with it. So I want to make sure those people are not on my jury panel, because they're going to be more inclined to find in favor of the prosecution.
Are there a certain number of strikes that, depending on the trial, or is it a same amount of number, doesn't matter?
It's going to be, in this case, it's going to be 5 for the state and 10 for the defendant.
Okay, why the difference in numbers?
It's statutory.
Okay. So when it comes to something like that, does that mean they get more questions to ask, or no?
All that is discretionary for the judge, but typically no. Each side has, 5 and 10. And when I say that, those are just peremptory strikes for which they don't need to give a reason. Mm-hmm. Now, you can challenge anybody for cause. Okay, if you have a legitimate reason to argue, Judge, this person should not be on this panel, you can make that argument. And typically what always happens is at the conclusion of the panel being seated, the defendant may, if the defendant doesn't like the jury panel, what the defendant can do is request a hearing and challenge the state's use of their strikes and require them to give a racially or gender neutral reason for why they struck that person, okay? Because that can't happen. You don't want a prosecutor saying, okay, we got a black defendant, let's strike all the black people off the jury.
So that's what I was going to ask you, is race, gender, age, could that play a part at all when jury selection, or no?
Well, there are 2 parts of that question. It should not, when it comes to race and gender, they cannot play a role in how the strikes are used, okay? Now, when it comes to the panel, the makeup of the panel, the cross-section of the panel, you can bet your dollar that it is a factor. You have an Asian defendant, of course. If I had a defendant from Mars, I want Martian on the panel. That's just, being smart. That's not racist. That's being a smart lawyer. You want people that identify with your defendant. You're a newscaster. If you're on trial, I want as many mid-30s newscasters, brunette newscasters on my panel as I can get. Plain and simple. But yes, it is going to be a factor in how the jury perceives the case, because your jury panel is going to make a decision based on their experiences. I think the best example, and to go down the rabbit hole a little bit on that, is the O.J. Simpson trial some years back. In the O.J. Simpson trial, that jury, that was seated in his case was from a part of Los Angeles that was not affluent, that had a completely different interaction with law enforcement than the more affluent sides. So you take that same case and you put it in Beverly Hills, Simi Valley, where law enforcement is friendly, the crime is not as bad. This whole idea that law enforcement framed somebody and lied about things, they just wouldn't believe that. That's never been their experience. But you take that jury panel from a community that sees that every day. They see police brutality. They see law enforcement being excessive with violence. They see law enforcement being disrespectful, being racist, being rude, lying. Now that defense is going to carry a lot more weight because that panel, based on their experiences, sees that. So my point is, again, that cross-section of experiences is going to be a big factor in how the jury perceives the arguments made by the state and the defendant.
So when it comes to this, who makes the final decision? All three sides need to agree on, including the judge, the prosecution, the defense, and the judge. Okay, this is who we have? Well,
it's random. What happens is, the clerk winds the basket, pulls out a number.
Sounds like a bingo.
It is. It's like juror bingo. Everybody's trying to get bingo.
There you go.
And she pulls out the ball that says juror number 55.
There you go.
Stand up here. And juror 55 is going to show up and stand up in front of the courtroom and say, my name is so-and-so, and this is what I do. My husband does this.
Gotcha.
Judge says, what say the state? The state says either go, yes, seat the juror, or please excuse the juror. And then if the state wants to, seat the juror, it goes to defense. What say the defense? And what I like to do when I try these cases is use this opportunity to try to connect with the jurors a little bit. And these little subtle details, I just think they can make a difference. So, like if you watch some trials, I'll see some lawyers, they will look down and say, seat the juror. But what I will do is, if I want to seat the juror, I'll look the juror in the eye and I'll stand up and say, Your Honor, please seat Mr. Rodriguez. Because, hey, I've used his name, I've made eye contact, I've smiled at him. I believe I've made a better connection than the person that's looking down at the paper, not even knowing his name, not even looking at him. So ideally, for me, my strategy is once that panel is set, they've already made a little better connection with me. Mm-hmm. So throughout the course of the trial, they're going to think, okay, Mobley's a nice guy. Hey, he was personal, but he was nice. He remembered my name, paid me a little bit more attention, and perhaps, if there's some close calls, to give me a little more of the benefit of their discretion as opposed to the prosecutors, So that's something I try to do during jury selection that I kind of learned early in my career. But it's crazy how so many lawyers don't do that. They just look down to their notes and don't try to make that connection.
Let me ask you about the publicity of how this case, really started back in May of 2023 to now. That was one of the reasons why they wanted to get this case out of Richland County. How do you start questioning jurors on, have you watched this case? Have you heard about this case? And do you believe them? How do you?
Well, ultimately, do I believe him most of the time? No, I don't. I can tell you that even if, and let's kind of back up, and I've had experience trying a lot of high-profile cases and paneling jurors in high-profile cases, and I'm going to talk about this process of change of venue, which, the defense made a motion for a change of venue that was denied, and I want to make sure everyone understands, the way it works when you're requesting a change of venue in South Carolina. When you watch the lawyers on TV, you see the lawyers stand up and ask for a change of venue based on pre-trial publicity, and judge says, yeah, I think you're right, this case got a lot of publicity, and they move it. It doesn't work that way. In South Carolina, the law requires the judge to try to impanel a jury first. You got to try to impanel that jury and see if you can seat a fair and impartial jury. That is all that is required in South Carolina, that the jurors indicate and the court believes they can be fair and impartial. So one of the voir dire questions, which I forgot to mention in a case like this, would be, has any member of the jury panel heard anything about this case before today? Mm-hmm. And you'd be surprised how even in these high-profile cases, people just say no. And and I think it's different nowadays because there's just so much information out there. There's so much news. I mean, even if something happened one day, 2 days later, something else happened, and we have so much more access to news than we did a long time ago. We have, and it's a 24-hour news cycle. We got social media. People have shorter attention spans. So they can say, yeah, they heard about this case. And, but the next question is, okay, well, despite the fact that you've heard about this case or seen it on the news, can you be fair and impartial? And most jurors are going to say yes. And that is the standard. That is all the law requires. Most people are going to say, well, yeah, I'm not a moron. I saw something on the news, but I know that's not everything. I got to hear all the facts. I got to hear from the witnesses. And based on that, I can make a decision. I don't have, oatmeal for brains that because I read something in the news that I'm going to make a decision. But you have to try to do that. Now, I've actually had a personal experience where we went through that process. And I found, and I was able to establish to the judge that the jurors actually were not honest based on their responses and based on the witnesses. And we did individual voir dire, and they gave different responses individually than they did in the panel. And I could show the judge they just were not being honest. And I got the case moved to a different county. But again, that was after half a day of trying to impanel a jury. You can't just ask for a jury to be changed, jury of change of venue and get it without trying to go through that process.
So could that then be still back on the table to move this out of Richland County?
It is always on the table, yes. I think it's unlikely. And again, there's just so much crime nowadays. And it's just not, I just think that most jurors are going to say they see crime all the time. You almost get numb to it. I hate to say that. That's a horrible thing to say when you talk about somebody being shot and killed. But I just don't see the jurors saying they can't be fair and impartial in this case. And I don't see, I think it's highly unlikely they'll be able to get a change of venue after they try to impanel a jury.
Okay, after this whole
Correct.
process. When it comes to kind of wrapping everything up and everybody is satisfied and everybody is good to go and the trial is set to begin, the jurors just come right back tomorrow morning and just ready to go? Yeah,
typically what happens is once the jury's impaneled and sworn in, the judge, depending on couple of things, how late in the day they finish.
Right.
If you get your jury impaneled fairly early in the day, he'll probably let them go to lunch early. And from there, typically the attorneys have pretrial motions, which will take, depending on the case, it could take 30 minutes, it could take 2 hours. So based on that dialogue with the attorneys, okay, well, does the defense have any pretrial motions? What are they? How long do you think it's going to take? The judge may decide, something, by the time we finish pretrial motions, it'll be 4 o'clock in the afternoon. Let's let them come back in the morning. Okay, so that's, and again, depending on the nature of the pretrial motions. Now, I know this case has had a number of pretrial motions already.
Yep.
Trying to fight search warrant, stand your ground hearing. Suppression of evidence and things like that. So my thought is most of those have already been resolved and they're probably going to get to it fairly quickly.
Okay, so and kind of going into that process to get ready for tomorrow.
Or this afternoon.
Or this afternoon.
In which point they start with opening statements, first the prosecutors and then the defendant.
Okay. Kind of going through, of course, your own notes with everything. As this process kind of goes around, are there anything specific that even during this jury selection the defense would want to ask? I think you kind of mentioned that. Does that kind of sway the jurors at all? This is what you're going to be talking about, and this is how we're going to convince you that he's guilty or not guilty?
Doing jury selection?
Yeah.
I think that you kind of have to keep, no, not really, because typically the judge is typically asked those questions, and it's just a question and a response, not an ongoing dialogue.
Okay, so is it more like a yes or no?
Yes, have you been a victim of violent crime?
Gotcha.
For example.
Yeah. Anything else? Any takeaways? Anything that we kind of missed, especially now that we know that, again, of course, before you sat down, before we found out that we aren't allowed to be there in that jury selection, and then kind of going into tomorrow, what are your final takeaways during this chat?
I do want to address the stand your ground hearing and to make sure everyone understands what that is. Basically, in layman's term, a stand your ground hearing is when a defendant believes they have a strong self-defense claim, and they have a hearing and to try to get a judge to say, something, your self-defense claim is so strong, this case doesn't even have to go to trial. They can't even prosecute you, okay? And that's pretty much what a stand your ground hearing is. Now, it's great if you win because it's game over for the prosecution. However, there's a big downside to that if you lose. Because if you lose and the judge denies your motion and the case has to go to trial, well, now you've laid out the majority of your self-defense case to the prosecutors. They know what you're going to say. They know what your witnesses are going to say. They're locked in on statements. They know what you're going to argue, and they can adjust their prosecution to address your self-defense claim early on because they know exactly what you're going to say. And that's always a double-edged sword. I mean, I understand that you kind of got to make the decision you think is best, and sometimes, your client will want you to push for it. I had that recently. I decided not to do it for that reason, because I did not want to give away my entire defense. And, if I lost a stand your ground hearing, because I do believe that when you're defendant in a criminal case, one of the biggest weapons you have is surprise. You want to keep the majority of your witnesses' testimony, your evidence, your defense theories. You want to keep as much of that from the prosecutors as you can until it's too late, because if they don't know about it, they can't prepare for it. I use the word Pearl Harbor. They got Pearl Harbored. They got surprised, because now when these bombshells, let's say you got a bombshell, you got a blockbuster, you got some details that they would not or could not have known about, they got to respond to them on the fly now. They haven't had the time to prepare for it by asking their investigators questions or investigating witnesses to counter it or undercut it. They've kind of got to deal with it in real time with the lack of preparation. And that is it's a big advantage the defense has, which is, again, that is the flip side of losing this stand your ground hearing.
Okay. I appreciate it, John. Thank you so much for being here.
Thank
you so much for chatting. And of course, as always, we'll be keeping you all informed. And of course, as always, put it on our website, WLTX.com.